Hello, everyone, and welcome to One Civil Law. And my friends, when it comes to the Nick Rekieta story and Kayla Rekieta story, I'm afraid for this couple, legally, things are over when it comes to their drug case. There are no more moves left to make, and all that's really left is the fall. And how one falls, well, it matters. I suppose we'll see how it goes as it relates to that. We turn our attention to the case of State of Minnesota versus Kayla Rekieta, Nick Rekieta's wife. In her motion to suppress, we gave her a 1% chance of success. She didn't succeed. No surprises. And we're going to read this for what little value it has, and we'll discuss what we think is going to happen as things progress. This above matter came before the Honorable Judge Stephen Wenzel, SJW, indeed, for an omnibus hearing at Kandiyohi County Courthouse in Wilmer, Minnesota. The defendant, Kayla Rekieta, appeared and was represented by counsel. The state of Minnesota appeared and was represented by counsel. Defendant Kayla Rekieta is charged with second-degree controlled substance, possession of firearm, and child neglect or endangerment. At the hearing, the state offered and the court received without objection Exhibit 1, the application for the search warrant and receipt, inventory, and return, because this is all about whether or not there was sufficiency of the search warrant, which, as we've sort of discussed before, is decided by the four corners of the search warrant, right? Because that's what the judge had. The judge had the search warrant affidavit, and so if it was sufficient or not should be determinable on its face, because obviously that's what the judge had to make the determination on. So that's what we're going to do. So there's not really much beyond that. Following a briefing schedule, the court took the matter upon advisement on December the 9th. Based on the files, exhibits, records, proceedings, and being fully advised of the premises, the court makes the following findings of fact. On May the 22nd, 2024, Quinn Pomplin. How you doing, Quinn? Hope you're having a nice new year. Of Kandiyohi County Sheriff's Office, submitted an application for a search warrant, supporting affidavit and search warrant regarding the premises. The address subject to search warrant was known to Deputy Pomplin to be the residence of Rekieta and their children. The search warrant was for controlled substances, and that part is a bit important, as we've discussed before, because what the search warrant is for will dictate, for example, where we can look, because you're sort of allowed to look anywhere where that item might be readily found. Is sort of the short rule. Like, where can I go look for the thing? Well, it's where the thing can likely be found. So am I searching for a stolen automobile? Where can I go look? Well, I can go look in your garage. Can I go look in your closet? No. The car won't be there. Right? That kind of thing, right? So where can the thing readily be found? And with drugs, the answer is, where can the drugs be found? The answer is just yes, because people have hid drugs just about everywhere. So drugs basically give you a right to look essentially everywhere, because the drugs can be found essentially everywhere. So there's probably somewhere you're not allowed to look for the drugs, but it's probably a pretty small list. So you're kind of allowed to look anywhere because drugs. Okay. So that part's kind of important. Anyway, so the search was for controlled search warrant, for the controlled substances, paraphernalia, and items that show that the drugs are not legal. The search warrant was signed by the district judge, as one does. The search warrant application states that on May the 16th of 2024, the Kandiyohi County Sheriff's Office, Sergeant Dave Nestor, how you doing, Dave, received a report of possible child neglect and controlled substance involving the defendant. So the investigation started its life with a complaint from a mandatory reporter saying, we have concerns about child neglect. That is where things started. But investigations go where investigations go. And although we didn't really find really great evidence of child neglect, we did find some evidence relating to controlled substance use. And that's perfectly okay, because investigations go where investigations go. I was investigating you for one thing, and along the way, I'm like, well, that doesn't really work, but I found some interesting evidence along the way of a different crime. So how it started and how it ended, are not necessarily the same thing. So it started with a report of child neglect. It didn't really end that way, but that's okay. Deputy Pomplin reviewed Nicholas Rekieta's social media videos. He sure did. Detective Pomplin notes that Nick Rekieta's appearance changed from January to May. It certainly has. Nick Rekieta's changes in appearance are noted as common with controlled substance use. A reasonable conclusion. Also, as we saw in his later videos, the way he was behaving on screen suggested he was being impacted by something. Detective Pomplin, or Deputy Pomplin, reviewed Aaron Imholt. How you doing, Aaron? Social media videos. Imholt hosts his own social media video programs. From watching Aaron's videos, it's apparent that the Rekietas and Imholts previously had a friendship and since had a falling out. They don't seem to be getting along very well. Imholt states the video he had recently experienced with cocaine and Molly. On May the 22nd, 2024, Imholt uploaded a video where he spoke about Nick Rekieta and insinuated he was using controlled substances. During Imholt's May 22nd, 2024 video, he referenced a video posted by Nick on May the 21st, 2024. Was it really that long ago? Was it really May when that video came out? It doesn't seem like it was that long ago. Was it really May? Time flies, man. Time flies. Imholt knows that white powdery substances can be seen on Nick's nose during May 21st, 2024 video. Nick Rekieta's May 21st, 2024 video was removed from the internet, lol. Well, that's not really, strictly speaking, true. It was removed from YouTube, but, fine. Detective Pomplin was able to review Nick Rekieta's video, Nick Rekieta's May 21st, 2024 video is 4 hours and 4 minutes in length. At approximately 2 hours and 46 minutes, presumably, Nick Rekieta leaves the video to use the restroom. Upon his return at approximately 2:40, Nick Rekieta appears with a white powdery substance on his nose. Nick Rekieta's demeanor is excited. At one point, he closes one eye to be able to read the screen, rambles, and slurs his speech. Yeah, that kind of happened. The May 21st, 2024 video was recorded in the basement studio of Rekieta's home. It sure was. Detective Pomplin was previously a drug-recognized evaluator. Based on Deputy Pomplin's training and experience, which are pretty much magic words when it comes to the police, they love that phrase, training and experience. It's like one of their favorite things. Nick Rekieta's behavior in the May 21st, 2024 video indicates a polysubstance abuse. And poly abuses beyond substances, perhaps, as well. Deputy Pomplin notes that Nick Rekieta's behavior is consistent with using both a central nervous system stimulant and depressant. On May the 23rd, 2024, law enforcement officers executed a search warrant and they found some stuff. We will skip the stuff. Mostly they found drugs and guns and drug-related stuff. We've gone through the list before, so we don't need to discuss it again. Therefore, the motion to suppress all evidence, statements, and confessions resulting from the search of the home is denied. Motion to dismiss is denied. All other omnibus issues not argued with particularity or otherwise specified are, of course, denied. Court administration shall schedule a settlement conference, and the memorandum of the court is incorporated by reference. And now let's do our legal analysis. So those were all statements of fact. So let's do statements of law, or conclusions of the law, I suppose. Defendant asserts the search warrant was defective because it lacked probable cause, as the information had no indicia of reliability, was conclusory, and based on speculation. And Detective Pomplin lacked training and experience. The court disagrees. No shit. And we again sort of note that several things. We note that search warrants are very low quality, generally speaking. We don't need a lot of certainty for them. If proof beyond a reasonable doubt is something like 95 to 99%, if preponderance of evidence is something like 51%, what is probable cause? It's something like 10 to 20%. It's something in that range. It's not very much. Plus, the evidence that we can use doesn't need to be the same quality of evidence that we would use at trial. For example, hearsay is not permissible at trial, unless, of course, it falls into a hearsay exception. However, hearsay is generally allowed in a search warrant application as long as it's sufficient, as long as it's reasonably reliable. So it's a much lower standard. So you can have hearsay. You can have hearsay upon hearsay. I heard from a guy who heard from a guy. As long as those guys are reliable, as long as they are like reasonably reliable, it's a much lower standard. So we don't need very much evidence. And then the nature and quality of the evidence we need doesn't have to be very good because we're not trying to prove very much. We're just trying to prove that it's reasonably probable that you committed the crime and evidence of the crime can be found in the place that we're looking to search. That's all we're really trying to do. Right? And so it doesn't take very much. And the courts have consistently held, basically, that search warrants should be presumed to be reliable because they were issued by a judge. So basically, to undo that, you have to show that it was obvious the judge shouldn't have done it. The judge just screwed up, right? The judge was biased in some sort of material way, or the judge was just off their rocker that day, or something like that, right? You have to kind of show that on its face, there was corruption, on its face, this was wildly insufficient. The determination of the judge is going to be given a lot of deference. And so you kind of knew from the get-go that you were in a lot of trouble. The thing is, of course, it happens every day, right? It happens every single day. Every single day, cops go and get search warrants and they search properties all across the nation. It happens every single day, multiple times a day, right? And of course, the court systems continue to operate, right? We continue to have court cases. We continue to have criminal trials. So you can kind of just, just by putting two and two together, realize that search warrants are usually valid because, well, it happens every day and we have criminal trials every day. So it must be that search warrants are pretty much valid every single time, right? Otherwise, the entire system wouldn't be operating, and it is. So you can kind of just understand, you can just kind of look from the fact that the wheels are turning, that they're valid. It is by far and away the exception, not the rule, that they're invalid. That's pretty hard to do. So yeah, I mean, completely unsurprising. The United States and Minnesota constitutions guarantee the right of the people to be free from unreasonable search and seizure and provide there must be a finding of probable cause in order to issue the warrant. In most instances, before searching a particular residence, a neutral and detached magistrate must find probable cause to issue a warrant. Fair? We could get into search warrant exceptions, but that's not what we're doing today. The court reviews a probable cause challenge to a search warrant by considering the four corners of the affidavit, because that's what the court that issued it considered. The court that issued it considered the four corners of the affidavit. So is it sufficient on its face or not? Probable cause to issue a search warrant exists if the affidavit sets forth competent evidence sufficient to lead a reasonably prudent person to believe there's a basis for a search. The reasonable man test. Would the reasonable person think that there is competent evidence that believes that this is reasonably probable? Probable cause is determined under the total circumstances. In reviewing for sufficiency of an affidavit, the court must be careful not to review each component of the affidavit in isolation. We've discussed that at some length. Search warrants must be understood in their totality. We don't do this piecemeal. As I sort of said, very early on in this analysis, even if you could attack the individual parts, it wouldn't matter because it's to be understood in its totality. So it's like, even if I put my legal hat on and I could make pieces of this disappear, it wouldn't matter because the analysis is totality, and I can't possibly make enough of it to disappear to matter. So that's kind of what the court is saying. It's like, yeah, we're not doing this piece by piece. We're doing it as a total impression almost, if you like. Once the issuing court issues probable cause exists, a reviewing court may not engage in a hyper-technical examination. Again, this is not based on, looking for stray commas or a stray period. This is not looking for, oh my God, oh my God, the witness said the hat was blue. And when we went in there, it was really teal. We found the hat and it was really a teal hat, not a blue hat. And the courts are like, close enough. It was really a black hat. Close enough. right? It was really robin's egg blue. It was pretty light, Your Honor. Close enough. So we don't really do hyper technical. We're not trying to, squeeze this thing for life. Again, we're just trying to see, is there sufficient probable cause to attend a 20% standard? So we're not looking for beyond a reasonable doubt or anything close to beyond a reasonable doubt. All right. But should pay great deference to the magistrate's determination. The judge that issued it, basically any reasonable judge, would any reasonable judge have signed this? Is sort of the standard. The determination of probable cause must be based on information presented in the affidavit supporting the search warrant application, not additional information known to the police. Because again, of course, it has to be in the search warrant. And if it's not there, then how could the judge rely on it? And if the police have super secret information that would have led to this being issued, but they didn't tell the judge, well, then that's a real problem. Maybe you should have told the judge about the super secret information, right? If it's not on the record, it doesn't exist, as we were sort of discussing yesterday in our analysis relating to the Honey lawsuit, right? If it's not on the record, it doesn't exist. So if you have super secret information, please tell the court about it. Otherwise, the court can't possibly rely on it. If there's enough there, there's enough there. The police are not obligated to tell, nor is a plaintiff in a lawsuit. They're not obligated to tell the court everything they have right from the get-go, right? They're not obligated to tell the court everything they have from the get-go. They just need to have enough stuff there to get past the next step of the analysis. So they're not necessarily required to tell the court the super secret stuff if the super secret stuff is favorable to them, right? If it's favorable to the defense, they do have to tell, because they do have to disclose any facts they're aware of that would tend to indicate that this isn't the person that did it, or the evidence won't be found there. So any evidence they have that contradicts their premise, the drugs can be found there, they do have to tell the police or tell the court. But they don't have to tell the court everything they know that favors them. So they can hold things back that favor them, and there might be very good reasons to do that. But you still have to evaluate it based on the four corners of the document, because that's all the court had to work with. The reviewing court should determine if the issuing court has a substantial basis for finding probable cause. A substantial basis means, given the totality of circumstances, there's a fair probability that contraband or evidence of crime will be found in a particular place. And that's sort of like, if you want where's my highlighter? This is the, well, I can't apparently edit it for some reason, won't let me, but fair probability is sort of the thing that we're looking for, is fair probability. We're not looking for very much. We're just looking for fair probability. Okay. For the purposes of establishing probable cause to issue the search warrant, the required nexus between the place to be searched and the items to be seized need not rest on direct observation. No one necessarily needs to have seen the thing there. That would be nice, right? How do we know there are drugs in the house? I saw drugs in the house. Oh, that would be really helpful, but not necessarily required. The nexus may be inferred from totality of circumstances, including the type of crime involved, the nature of the items sought, and the extent of the opportunity for concealment, and reasonable assumptions about where a suspect would likely keep the evidence. If it sounds like there's a fair amount of guesswork here, there is, because again, the standards are low. Historically, the Minnesota Supreme Court has required a direct connection or nexus between the alleged crime and the particular place to be searched, particularly in cases involving a search of a residence for evidence of drug activity. In the present case, the search warrant application states that law enforcement began their investigation after receiving an allegation of child maltreatment concerning defendant's children, which, of course, roughly, globally, is not true, as that case appears to have been resolved. Still unclear how metabolites relating to cocaine was found in the one child's hair. But the child neglect case unto itself didn't seem to really go anywhere. So that seems to have been resolved in favor of the Rekietas. So, fair enough as far as it goes. The child neglect case didn't really go anywhere. Fine. Minnesota states statutes and regulations emphasizing the protection of the identity of reporters and informants in contests of child maltreatment investigations. As such, the search warrant does not include the identity of those individuals. So certain people can have their information, the name of them can be withheld relating to certain people. So the name of them can be withheld. The search warrant doesn't include the identity of those people. The people have to exist, but we don't necessarily have to refer to them by name, which, you know, would be also true of other kinds of informants as well. Confidential informants of many stripes. So confidential informants can exist as a matter of statute as well. So it's like, yeah, we're not going to refer to them by name, but that's fine as long as they exist. And incidentally, we know who they are, so it just wasn't in the application. Once the maltreatment investigation began, Detective Pomplin personally reviewed the defendant's husband's social media. Detective Pomplin was previously a drug recognition evaluator and has been licensed as a peace officer since 2009 with a wide variety of experiences and hundreds of hours of training. While reviewing a social media video, Deputy Pomplin observed Nicholas Rekieta with powder on his nose and behaviors consistent with being under the influence. The social media video was recorded in the Rekieta home. Police officers may rely on their training and experience to draw inferences in affidavits, but mere suspicion does not equal probable cause. Right? I have to have some evidence, but what that evidence means, I might be able to make some conclusions from it. So like, why do I believe it's true? In this case, because I saw powder on the nose. I saw him acting a certain way. And so therefore I can conclude based on this evidence that exists, there is powder on the nose, he is behaving a certain way, I can conclude that that is drugs, right? So that is not mere suspicion. That's not mere, I think it's true. That is, I have some evidence that I can then use to deduce its truth. Again, it may not be true, because we're not trying to determine whether it is true beyond a reasonable doubt. We're not trying to determine whether or not he really did have powder on his nose. We're not trying to determine whether he really was under the influence of drugs. We're just trying to determine whether or not it's sufficiently plausible to support a search warrant. So maybe it wasn't powder on his nose. Maybe it wasn't cocaine, and maybe he was acting up. Maybe he was putting on a performance. Maybe that's what it was. But what it was and what it appeared to be do not necessarily have to be in concert. And then the cops can rely on what it appears to be. You know, that you make a demonstrating it to be that thing. The cops can believe it's that thing. And if it's not really that thing, well, you know, then I guess your performance was just really good. I don't know what to tell you, but they believed it. So either way, it's going to be sufficient. Detective Pomplin also noted that Nicholas Rekieta's appearance changed from January 2024 to May 2024, consistent with controlled substance use. Fair. Based on Detective Pomplin's experience as a drug recognition evaluator and observations of Nick Rekieta, he believed Nick Rekieta was exhibiting signs of polysubstance use. The observations made by Detective Pomplin of Nick Rekieta's behaviors are detailed within the search warrant affidavit and further corroborated the reports concerned about Nicholas Rekieta and defendant using the controlled substances. For example, the report from Aaron that he made on social media, for example, saying, I think he's using drugs. It's like, oh, okay, I find some evidence that supports that proposition. As a whole, the evidence presents specific facts which demonstrate support for a warrant seeking controlled substances in the residence. The court does acknowledge that using social media video as support for a warrant is somewhat unusual, although that part I'm not really sure is really fair, to be honest, by the court. I think the court's being overly conservative here because in our day and age, social media video is like one of the most common things, you know, by police. So people ratting on themselves on social media. Yeah. So social media, I'm not really sure that it's rare or unusual. So I think the court statement here is overly conservative because, well, social media videos are used all the time because people can't help snitching on themselves, apparently. So the court says, anyways, they acknowledge that social media video as support for a warrant is somewhat unusual, okay? And caution must be used to ensure an altered video parody are not used as support for a warrant. I suppose we can take note of the possibility of fakes. That's fair. We can take note that there's a possibility that the evidence is faked in some way. In this case, there's no indication that Deputy Pomplin did not watch the video, nor is there any evidence the video is altered or parodied or otherwise inconsistent. But my watermark, though, we don't care. But my watermark, we don't care. Considering the totality of circumstances, information provided demonstrates a fair probability, 10, 20%, something like that contraband of a crime would be found in their residence. Accordingly, there's sufficient information in the affidavit to establish probable cause. Defendant motion to suppress and dismiss is denied. And thus ends the story with respect to Nick and Kayla Rekieta's story. That sort of ends it with respect to their story. Still to be decided, of course, is April's story, because we got Nick and Kayla from constructive possession, right? They own the house. Did you know that? Did you know they own the house? Well, they own the house for the moment. The house has been listed for foreclosure, but for the moment they own the house, and therefore they have constructive possession. With respect to April, in her case, she doesn't live there. She didn't claim to live there. The state so far hasn't proven that she lived there. So they're not making a constructive possession case. Whether or not such a case could be made or not, I don't know. But of course, if it's not on the record, it doesn't exist. So for at least so far, they haven't attempted to prove that April lives there. They haven't attempted to prove constructive possession. So they have to try to prove actual possession. Now, they have her credit cards in the bedroom. And if we go back to the evidence of probable cause, I'm not sure if it's in here because it wouldn't necessarily be relevant to them. But her credit cards were found in the master bedroom and on a table in the master bedroom. And if we go to like the things we did find with respect to drugs, for example, we have this yellow snort tube in the master bedroom near the nightstand where the credit card was found, field testing positive for the presence of cocaine. This black vial with a white substance inside the master bedroom near the nightstand, both items testing positive for cocaine. So we do have some evidence to suggest use, but we're charging her with possession. And so her case is a bit stronger than Kayla or Nick Rekieta's case. So it'll be interesting to see how that develops. Her case could very well wind up being dismissed. We'll see how it progresses. But there's a lot more hope for April than there is for Nick or Kayla. Their case is over. The only thing left really to do here would be for Nick to fall on his sword, which may not even work. But that would be like the only thing left to do. I suppose Kayla could try to fall on her sword, which people would really judge the hell out of Nick for. Could you imagine if Kayla tried to go with, it's really all my drugs, Nick doesn't use drugs at all, this is all me, it's all 100% me. Could you imagine if Kayla tried to fall on her sword? I'm not imagining that would go over very well with a lot of people, but holy shit. I mean, I suppose that's the only way this can get any funnier. But the only thing really left is a strategic move here is for Nick to fall on his sword and say, the drugs are all mine. My wife has nothing to do with it. They're all mine. And she's completely innocent, doe-eyed and whatever. And, you know, tried and just take all the responsibility forever, right? That's the only thing left to do. And that may not even necessarily be successful, but it's the only move left to try. But I don't really see that happening. So in terms of Nick's resolution of this case, for Nick Rekieta, I've said before, and my best bet continues to be fourth degree. There's going to be a plea to fourth degree, about 2 years probation, and one or both of the misdemeanors will be dropped. So that is my best prediction. And we're going to find out in about 20 days, a little less than 3 weeks, how close I am in terms of this. But that is my best guess. I don't see this coming out without a felony. So my best guess on the plea for Nick is a plea to 4th degree, about 2 years probation, and 1 or both of the misdemeanors dropped. And we'll see how it goes. In terms of Kayla, I don't know. She doesn't feel like she's messed around, and she doesn't feel like she has been as aggravating necessarily to the state. So there still might be some kind of out for Kayla. So Kayla could potentially come out of this thing without a felony, although I wouldn't necessarily bank on it because, again, 2nd degree. And the problem, of course, is like you're asked, right? You're at 2nd degree, and you're like, how about nothing? That's a pretty big ask, right? If it were 5th degree, which is the lowest it gets on the drug possession, right? If we were starting at 5th degree, and you're like, how about nothing? So you're not asking for as much, but you're at 2nd degree. So you're like, how about not 3rd? How about not 4th? How about not 5th? How about nothing? You're asking for a lot. So it seems unlikely, but it would not surprise me if Kayla comes out of this with a better deal or a better offer than Nick. So maybe Kayla comes out with 5th degree. And maybe if she's really, really lucky, she could come out with some sort of deferred adjudication. And if she keeps her nose clean, maybe the charge doesn't actually get put on her record. Although I wouldn't bank for it. I think the odds still favor a criminal conviction for Kayla, perhaps a less severe one. But we're going to find out in about 20 days how close I am to that prediction or not. And also, of course, as I sort of mentioned, their home has been listed for foreclosure. So that raises a lot of interesting questions because the mortgage was taken out only 2 years ago. The home was owned free and clear. The home was owned free and clear. And it was at the time when they were doing as the most well financially. It was during Rittenhouse and during DEP and stuff like that, where they took out this mortgage, which is really odd, right? Because it's you're getting all this money from Rittenhouse because, Nick had 150,000 people peak for Rittenhouse, and he was doing very, very well for DEP as well. I mean, he was doing very well. He was, raising significant amounts of money. And where did it all go? Where did it all go? Is a very reasonable question. How do you blow through what $350,000 in a mortgage plus all the stuff? How'd you set $1 million on fire? I mean, cocaine isn't that expensive, I don't think. Damn. So what were you doing? How'd you set $1 million on fire? Holy shit. So I don't know, man. So we'll see how that progresses. But at the moment, his house is listed for foreclosure, and his parents might have money, but the degree to which they're willing to bail them out, who knows? We'll see. So, yeah, vacation, artwork, drugs, expensive dinners. I guess. I don't know, man. People can spend way more than that on coke. $1 million? That's a lot of cocaine, man. And he also had a contract from Rumble at the time. That's true. So he also had a contract from Rumble. So he was bringing in a lot of money from DEP. He was bringing in a lot of money from Rittenhouse. He had a contract with Rumble. He had his locals. And he also needed...
Donation from NIN Gal 1994.
Thank you for the donation. I appreciate it. That's very thoughtful. So, what's going on there? So where did $1 million go? I mean, he bought that car for $100,000, so I guess that's that. But Still, where'd $900,000 go? Does he have a second home? He does have a second home. It was previously listed for sale. He does have a second home, which was also itself listed for sale. So it looks like he has serious cash flow problems. Is it really questionable what else was going on that he needed cash money? Yes. Yes, at least to me, it's really questionable what was going on that he needed cash money. Yes. I mean, it just seems like a lot. So maybe they will wind up moving into the second home. Maybe they'll wind up moving out of the main home and move into the guest house, where April may or may not live at the moment. April may or may not have to find new digs. $2K a week for snacks for the kids adds up. I mean, yeah, I mean that would be a lot of money. Nick likely gambled away his house. Gambling would certainly explain it. If he has a gambling habit, that would certainly explain it. Yeah, but I don't know that there's any evidence of that. But if that turned out to be the case, that would explain it. Could it be a way to avoid asset forfeiture? Not really, no. Because if there were going to be an asset forfeiture, like, he still owns the house. So if it were going to be seized, it could still be seized. So I don't think that makes any sense. Didn't he blow money on the suit with Monograph? Yeah, he did. And eventually he's going to have to wind up paying Monograph a whole bunch of money. From where, I don't know. A lot of scratch and win tickets. Perfect way to burn money? Maybe. Minnesota's love their scratchies. That is a lot of scratch off tickets. That is a lot of scratch off tickets. Nick's home is in foreclosure? It is. Yeah, his main home is in foreclosure. The notice was put on the, yeah, his home is in foreclosure. So he took out a $350,000 mortgage and hasn't been paying it. So, like, where'd it go? Where'd the money go? Plus the money he was making from all those sources, like, where'd the money go? It could be an addiction thing. It could be drugs, drink, and gambling. It could be gambling. That would explain things, I suppose. He took out a loan using his home as collateral. Right. That's what the mortgage was. Yeah. That's what a mortgage is. Yeah. Yeah. He took out a loan using his home as collateral. Yeah, that's what a mortgage is. Correct. That's correct. Yes. I'll never understood the joys of gambling. Yeah, I've never really enjoyed gambling either. I played some house stakes poker, a couple years ago. I was doing okay, obviously. I was just like with friends, but but like I've gone to Vegas and I don't get it. I don't get it. It's just it doesn't do anything for me. I've tried playing poker at a casino a couple times and like just like that doesn't do anything for me. So it's not my bag. Minnesota casinos are much different than Vegas. I'll take your word for it. Plus, of course, anyone who knows anything about math knows that most forms of gambling are just a bad deal. Like unless they're skill-based like poker, then, but almost all forms of gambling are a bad deal. It's because you're just going to lose money. So like, it's just a bad deal. So, why would you do that? Right? Why would you do that? It's like, why would you do something when you're guaranteed to lose money? Basically. I mean, I certainly understand if like you're buying like, a Mega Millions thing, right? There's a Mega Millions and a big jackpot and you buy some tickets. I've done that before, right? There's a big Mega Millions and I buy like $20 worth of tickets. Just on the, to have the dream for a moment, to have the dream, but like, I don't really get like, and I suppose if you like got a scratch off, as you were going through the convenience store line, I guess, but I don't really understand it otherwise. It just doesn't make sense. It's a bad systemic deal. Incidentally, by the way, if you ever win the lottery, my advice here is to take the money and put it all into a nice index fund. I recommend the S&P 500 index fund. Dump it all into Spider with Vanguard, and then just live off the interest forever. Take out 2% every year, and you'll be able to do it indefinitely. Of course, you'll still have to pay taxes. So after you pay the taxes, do that. So first pay the taxes, then dump it all into an index fund. Spider is a good choice. In Vanguard, and just take out 2% every year, and you can do it forever. There's your lottery advice for the day. And if you live in a state which allows you to remain anonymous, then you probably should do that, and don't tell anybody. Potentially Criminal says maybe they brought scratch offs in Jamaica. Yeah. Horse racing is the only form of gambling I ever liked. The only thing with horse racing that I would ever do would be like to bet on the horse that's most likely to win to at least show, because I think that you basically break even if you do that. And then maybe if you live and then if you go to a casino that gives you free drinks, maybe you can get some free drinks out of it. But that's like, you bet on the horse that's most likely to win to show, and you should be able to break even. Do crypto like the Hawk coin. Yeah, we could do LawTube coin. That would be interesting. I do a rug pull. Could I just call it rug pull coin? I mean, it might as well, right? Just call it rug pull coin, and then people can't sue me for fraud. It's genius, actually. That's actually like that's actually might be the most genius idea I've ever had in my life. It's like, I'm going to start a coin. I'm going to literally call it rug pull coin. And then when I do a rug pull, no one can sue me for fraud. It's genius. It's genius. Big brain. Big brain. Nick can pick bulls, not horses. Big difference. Wow. Sean, we're feeling a little spicy. Sean, it's only 8:19 in the morning, Sean. It's a little early for that much spice in my day, Sean. Holy shit, Sean. Thank you for the super chat. All right, well, I'm going to go ahead and sign off while we're keeping this thing in some sort of semblance of reality. But things are not going well for Nick. So we'll see how it all ends. 3 weeks. 3 weeks, it's going to all come to an end. And we'll see what Nick pleads to. And then I assume we're going to get the transcript of his plea deal, which will be fun to read. And that'll be fun. And as for the body cam footage, by the way, as long as any of their cases remain active, I don't expect the body cam footage to be released. So I don't think the body cam footage is going to be released until all their cases are disposed of. So it's probably going to be a hot minute till we see any body cam footage. So I wouldn't expect to see it anytime in the near future. But then eventually someday the body cam footage will probably be released and we'll get to watch that too. And which, is actually like, if Nick were really smart, he probably would release it now just so that, it would be done. Because that someday it's going to come out and then it's just going to like revitalize everything all over again. So if you just like stall this thing out, for a year or whatever, and then it comes out, so it re-kicks up everything all over again. The smart move might be actually to release the body cam footage now. That might be the smart move. Because, you take the hit now, but then, you can actually move on from it. So I think Nick might be playing himself, because if he keeps this thing stalled out, then it could all come back to bite him out. So we'll see. All right, guys, I'm gonna see. Talk to you guys later. I hope all is well for now. Cheers, my friends, for now, and goodbye.